Welcome to Rebel Chaser. My name is Gail, and I've got several videos for you tonight. The first one is with Judge Mertz, and then there's one with Judge Mogan, then Hesselink, and then another one from Motsego, but I can't remember this judge's name, and then a couple from Judge McNally. I'll let you guys watch.
All right, hello. Okay, we're on the record in Sarah versus Sarah. This is file number 2311355. The record should reflect that all parties are present today by Zoom video, along with Mr. Sarah's counsel, Mr. Cutler. We're on the record today. Both sides have filed competing motions alleging that the other side is not complying with the judgment of divorce. I've read those motions, so I'm aware of the basis for each side's complaints in this case. Ms. Sarah, what is it that you would like to say on your behalf here today?
Well, I still have not received any pension. It's now 5 months owed. I did receive an email from the pension company saying he finally completed the paperwork in June, which it was supposed to start in March, so I don't know where that's going. As far as I have never had them in my possession. My son has them, and my son told me that he had talked with his father, and his father agreed that my son would hold on to them until they figured out what to do. I've never had them in my possession. So I know he keeps saying I do, but I don't know anything about them. Why would I want them? A few were sold by my son just after I was forced out of my home. They made the car payment for a few months because I had no income, and they paid for my son's storage in California while he moved here. Also, he claims that I am late on the car payment. Well, he was supposed to pay the March and April car payment and insurance, and he never did. He still has not. I got a letter saying that, or an email saying that the car insurance is still in effect. Well, of course it is. I had to pay it, but he was supposed to pay March and April. I went without car insurance for 5 days, didn't drive the car because I had no money to pay it until I got support from him. At this time, it's over $5,000 with when you count the pension, the car payments, the insurance. I don't know what to do from here. I'm at a loss.
Okay, thank you. Mr. Cutler?
Thank you, Your Honor. Couple things. First of all, I want to correct the plaintiff in this. The judgment was entered May 13th. The judgment was required in order to process the quadro. That had to be submitted because it's an order of the court. That was done, so it hasn't been 5 months. It's now in the third month, I guess, because it was on the 13th, short of the third month. My client has jumped through all the hoops. He submitted the final documentation. He'd be happy to acknowledge that under oath. So that is done by third parties, not by my client. He submitted everything he needed to submit. As far as the current status of the situation, our greatest concern, as highlighted in our motion and our answer, is that there's a car. The car is being driven. It was awarded to the plaintiff. It is being driven by her. If she runs over, God forbid, some person gets into a car accident, gets a ticket, it falls on my client. He is liable for it. No matter what she says, he's going to be held liable because he's still down as the owner of the vehicle. We believe it's appropriate that until such time, if she is ever to get a car loan and ever to take the title out of his name, that the car be parked and that it remain there. So we're suggesting the car be transported to my client's property, what he was awarded during the divorce. It will remain there, will not be driven. And nothing will happen with that vehicle, thereby alleviating the possibility of other lawsuits and other traumatic situations. We believe that's appropriate in the interim until something may or may not happen. In her answer, she indicates she went to Secretary of State and there's a lien. Well, of course there's a lien because there's a car loan on it and she can't transfer it. I don't know if she's ever going to be approved for it. So that's the initial, I think, most urgent request at this point. As far as the remaining funds, she has not paid half the money for the student loans like she was ordered. We believe that it's appropriate in order to prevent default and other further problems for the two of them, that the amount of, I believe it's $714, I put it in my motion, be credited to my client, that he can reduce that from his support obligations that he has been making, and he has done so every month. He made every payment. He's going to be fulfilling his July payment, but that amount be reduced by that $700 figure. He will pay it on their behalf, avoiding a default, and thereby alleviating further problems for the two of them until such time when maybe situation will change. As far as the order of this court was very clear. If they are not returned to my client, he is to get credit for them. We added up exactly the amount for the attachment that was provided at the time of trial and as part of the decision of this court. The amount is $6,131.35. We've attached, in response to her motion, text messages where the the plaintiff is gloating. She forged my client's signature on these firearms, on the registration, that these firearms were all sold. Doesn't matter what the purpose is. That's all water under the bridge during the trial. Since they cannot be returned and she cannot apparently pay the amount of money, we believe it's appropriate he should have credit of that amount for the spousal support. So he's not creating more problems for himself. They're never going to be returned to him. He never had an agreement with anyone in the world. The decision of this court is very clear. She's supposed to return them. She's supposed to pay for them. She can't return them. Since she doesn't have the money to pay for them, we believe a credit is appropriate for that item. As far as the remaining aspects, when we filed our motion or after we filed the motion, it appears that the plaintiff did make a couple payments on the obligation for the Highlander, avoiding a default. So I'm glad she did that for the prior months, but she has not completed the other tasks. My client, on the other hand, has continued the the car insurance. It's paid through October 11th of this year because it was previously paid under a policy. It's a 6-month policy or a year policy as they typically are. So there isn't any continuing payment that needs to be made as far as the car insurance goes. But that's only short term, and that's going to be concluding pretty soon. So of those issues, we believe it's appropriate in the interim at this point in time, because we're not getting cooperation from the plaintiff, that he receive those credits, the credit for the payment that he's going to need to make for student loans, and that the vehicle be parked and remain parked and not to be touched by either party until further order of the court, which may or may not ever happen. I'm not sure if the court had any questions of myself.
I don't. Okay. So again, I've reviewed what each party's allegations are. First, I guess I want to say, and Mr. Cutler probably already knows this as an attorney, but for Mr. and Ms. Sarah, everybody needs to understand the way that I'm viewing this. The court has an interest in and an obligation to enforce its orders. And so the court's determination is limited to whether or not either or both parties are complying with the court's orders. And if they're not complying with the court's orders, whether they have a legally recognizable excuse for not doing so. And if they don't, then what punishment or what can the court do to compel compliance? What it's not the court's responsibility or duty to do is to figure out for the parties how they're going to comply with the orders of the court. Mr. and Ms. Sarah came to this court. They asked for a forum to resolve their divorce. The court did that according to the law and rendered a decision that in the court's view was as equitable as it could be under all the circumstances. As far as I know, neither party has appealed that decision. So now both parties are stuck with what the court has ordered, and both parties are required to comply with those orders on their own. And again, it's not the court's role or duty or obligation to figure out for the parties or answer their questions or come up with strategies or solutions for them as to how they're going to comply. That is outside the scope of the court's responsibility in this case. And we're not dealing with any legal issues here. We're simply dealing with compliance with orders of the court through the court's opinion and through the judgment of divorce that was entered. As we sit here today, just based on the statements of the parties, I don't think either party has complied with the judgment of divorce. The court's opinion clearly states that Mr. Serra is required to give or provide half of his pension to Ms. Serra, regardless of whether a quadro has been entered or not, beginning on March 1st. And Mr. Cutler has not, as far as I can tell, has not alleged that Mr. Serra has done that. The point that was made here is that he's going through the process of getting a quadro, but he's receiving that money every month. There's no reason why he can't remit to her half of that money. And in any case, regardless, it was the order of the court that he do that beginning on March 1st, and he hasn't done that, regardless of whether a quadro is entered.
And I apologize, Your Honor. I don't want to interrupt the court, but he is not receiving his full pension. He's only receiving half. Apparently, Ms. Serra needs to process some papers. So since the order of the court, he has only received half the pension. He'd be happy to acknowledge that on the record. The other half is waiting for Ms. Serra to fill out whatever form she has to fill out. I'm sorry I overlooked that portion. I'm sorry there's some confusion. I apologize for the interruption, but I want to make it clear. He has only received, since the entry of the opinion of this court, half of his pension.
Okay, well, I don't know whether that's accurate or not. I mean, Mr. Cutler, I accept your representation as what your understanding of it is. I don't know. I don't have any records in front of me that show that. All I know is what the court ordered. And I don't believe that those funds have been received. Mr. Serra was required to pay the car payment until the judgment of divorce was entered, which was in May. Apparently, he did not make those two car payments. Ms. Serra, pardon me, I'm sorry, I have a cold. Ms. Serra was required under the judgment to either return the weapons to Mr. Serra or provide him the value that was obtained for those weapons. I found, as a matter of fact, that regardless of whether it was the son that did it or Ms. Serra or a combination of both of them, somebody disposed of Mr. Serra's weapons, and he's entitled to those weapons. And so, Ms. Serra, you've got an obligation either through yourself or through your son to return those funds to Mr. Serra or return the weapons to Mr. Serra. In terms of the student loan debt, again, the parties are required to each pay half of that. It's not my job to decide how each of you are going to meet your obligation. I've simply determined that as a matter of equity, each of you should be required to pay that. And what I'm not going to do, because I can foresee this as being an issue, and I appreciate your suggestions, Mr. Cutler, in terms of crediting Mr. Serra for amounts that Ms. Serra may or may not owe to him. The problem with that is, how does that get overseen? And how does anybody really know how much Mr. Serra is withholding and whether he's actually putting those amounts towards the student loans or not? And I'm not going to hold a hearing every month and hold the hands of both these individuals every month and make determinations on a monthly basis about who's paying what and how it's being paid. So I'm going to make this really, really simple as we go forward here. And although, again, I don't think it's the court's obligation to come up with a solution, I'm going to provide the parties with an avenue for a solution before the court issues any kind of sanctions or coercive contempt actions. I'm going to give the parties 60 days to go to mediation. I'm going to refer this to the mediator. the community mediation. I'm gonna, in my referral to community mediation, I'm gonna outline the issues and ask the mediator to specifically address with the parties solutions so that the two of you can proceed on a monthly basis and carry out both of your obligations. And what it's really gonna come down to, because ultimately the two of you, Mr. and Miss Sarah, the two of you are gonna have to have some communications. The two of you are going to have to discuss how this can go forward, because ultimately any long-lasting solution to this problem is going to have to come from the two of you and not from the court. And that's why I think mediation is appropriate as a way to potentially go forward. I'm going to ask the mediator to provide the court with a written report following that mediation as to whether or not it was successful and to what degree. Typically, I just get a short report from the mediation service indicating whether an agreement was reached or not, but in this case, I'm going to ask for a little more detail from the mediator. And then to the extent that there isn't an agreement after that 30-day period, the court is going to set this for a show cause hearing. It'll be in person here in court. If either party has failed to comply with their own obligation under the judgment or the court's opinion, or has failed to reach an agreement as to how to meet that obligation through the mediation process, then at that point, the court will determine whether there is a violation of the court's order, whether there is a legally recognizable excuse for that violation, and if there's not, then the court will issue coercive sanctions. The last thing that I ever want to do in a civil case is impose some type of jail sanction to coerce a party to comply with the court's judgment. However, I think at that point, we will have exhausted all available remedies, and both parties should be prepared to the extent that they have not complied with the court's judgment, provided a legally recognizable excuse for not having complied, then the court will issue contempt sanctions, coercive contempt sanctions, which could include fines, other coercive orders of the court, or including up to incarceration until the non-complying party comes into compliance. I want to make sure that everybody is clear that again, this is not going to turn into a monthly finger pointing session about who's not doing what they should be doing. Both of you are adults, both capable of handling your own affairs. You both need to come up with solutions for how each of you are going to comply with your own obligations. I'm going to provide again an avenue through the mediation service to facilitate some communication between the two of you as to how to make that happen. And if it doesn't, then I'm left with no other option than to coerce you through the powers that I have. And I just want everybody to be clear that I will not hesitate to use those if that's the court's last option. So I will issue that order today, referring the matter to community mediation. When they reach out to counsel and the parties, everyone needs to cooperate with that process. Once I've received a report from the mediation service, then the court will set this for another hearing as necessary, and those orders will go out today. That's all I have. I need to move on to my 2 o'clock hearing. All parties are free to disconnect at this time.
May I, Your Honor, may I
Thank
say
you.
one more thing?
Nope, I need to move on to my 2 o'clock hearing. I'm sorry. Thank you.
Have a good day, Your Honor.
We will go on the record in the matter 25 CF 57 and 25 TR 326, State of Wisconsin versus Kelly Newman. The state appears through District Attorney Kevin Schmidt in person. We have Nicholas White, Defense Counsel, in person with Ms. Newman. We're set today in this matter for a status conference. Mr. White, can you please update the court?
Thank you, Judge. This case can be potentially resolved today. If you'll allow it, we have accepted an offer from the prosecutor involving the citation for the seatbelt violation and also to resolve the felony case by dismissing it and having Ms. Newman admit to a contempt of court finding here. I reviewed a plea questionnaire with her, just so that she understood all of her rights on the felony case. I've seen this type of charge be resolved this way one time before in St. Croix County, something similar, interference with parental custody being resolved as a contempt of court. I have a plea questionnaire for you if we can resolve this today.
Are we in victims' rights compliance?
Yes, Your Honor.
All right. Do we have
Okay.
victim here to make a statement?
No, Your Honor.
Okay. Thank you. And it's Wisconsin statute 785.01 paren 2.
That's right. That looks like the punitive section here.
All right, let me pull up
Make sure.
that statute.
And just to be clear, this doesn't count as a criminal disposition. I pointed that out to Attorney White, so before the court tries to colloquy it.
Okay, thank you. All right, so I do have in front of me a plea questionnaire waiver of rights form. Ms. Newman, did your attorney go over this document with you?
Yes.
Did she go over it? Did he, sorry, go over it thoroughly with you? And so you understand everything on this document?
I think so.
I believe there is cash bond posted, so for any,
500.
yep, anything can be taken care of. All right. So you understand everything on the document.
I think so.
And Mr. White, I see that you've checked no contest. Is there an argument or basis for a no contest plea versus a guilty?
Your Honor, just seeing it as a civil, I guess, non-criminal disposition. That's why I marked it that way.
But she is
But-
admitting to her contempt of court?
That's right.
Okay. So you're 45 years old, you have 10 years of schooling, you can read, write, you understand the English language, no drugs, alcohol, or other medications, is that correct?
No, just on heart meds.
Just heart meds, but nothing that'll interfere with your ability to comprehend or understand.
No,
And you were charged with crimes, and because you were charged with crimes, you would be entitled to constitutional rights. Each of those rights is listed on this document. Did your attorney thoroughly go over those rights with you?
yes,
And do you understand them completely?
I think so.
Do you need me to go over them with you in any more detail?
I'm not sure. I don't think so.
You don't think so, or you don't want me to?
I think I understand.
Okay, and you did sign this document, correct?
Yes,
And your attorney thoroughly went over it with you, essentially word for word, correct?
yes,
Okay, and so do you understand that if the court does amend this, that there is an offer that's presented and a potential recommendation for the contempt of court? But do you understand I'm not bound to follow that? You understand that? I could sentence or I could order all the way up to the maximum potential for the punitive, which could be a fine not to exceed $2,000, as well as potential jail time. Do you understand that?
yes, yes,
Do you still wish to proceed and move forward with the contempt of court?
yes.
Okay. Mr. Schmidt, formal motion to amend, please.
So made.
The court will grant the motion. Okay, so the state here with the punitive sanction will have to prove to the court that you were aware of an order or disposition of the court, and you violated that order or disposition of the court. So do you understand what would need to be shown to the court? You understand that?
Yes,
And you're admitting here today that you did violate a custody and placement order or guardianship order,
yes,
and you knew you didn't have any rights under that order to do what you did,
yes,
and yet you proceeded to, I believe here, you took a child across state lines, is that correct?
yes,
And the child was later returned unharmed, correct?
yes.
Okay. Mr. White, is there anything you would like to state on the record as it relates to this contempt?
I'm not sure what you're asking for, Your Honor. You mean a sentencing argument, situation,
just
or?
a basis as to why you indicated that this happened in St. Croix County before.
Oh, that's right. Your Honor, just seeing, the way that this, relates as the felony interference of, the child custody, and the facts here, I think that this is, appropriate as, a punitive sanction, that there was an expectation, that my client, wouldn't either have contact with the kid or wouldn't take the kid without permission, and that's what she did here. I think that there is a basis here for the facts.
All right, thank you. Is anyone threatening you or promising you anything to agree to be held in contempt of court in a punitive way?
No,
You're doing so freely and intelligently and voluntarily?
yes,
Are you satisfied with your attorney's services?
yes.
Do you have any questions for the court or your attorney before we proceed?
No,
And so based upon all of this, you are admitting your guilt or admitting your wrongdoing and violating a court's order and or judgment as it relates to either a custody and placement or a guardianship matter. Is that correct?
yes,
All right. Mr. Schmidt, the court will find her in contempt in a punitive fashion based upon all of that has been stated on the record. Argument, or would you like to provide an argument?
Sure. So the agreement is being guilty on both of those. So the ticket and the contempt. The ticket's $150.10 and 0 points. The contempt, we're asking the court to do 19 days jail as a punitive sanction, credit for 19 days time served. She's been in jail that long already before the bond. And then $1,000 fine with a $500 upfront. That's the bond. The reason for this is the essence of what Ms. Newman did is there's been a longstanding custody order with her grandchild. She's been aware of it and what the constraints are of it. She clearly knew that she couldn't just take the child whenever she wanted to do for whatever purpose. She did so anyways in this case. I think the jail time and the financial penalty, and she's also suffered the additional consequence that this was the impetus and the fact pattern for a 4-year restraining order, which has hampered her ability to have this contact as well. All those things together do the best to protect the public, appreciate what happened, and to punish Ms. Newman. Thank you.
Thank you, Mr. White.
Thank you, Judge. Ask you to go along with our recommendation here because my client did spend just about 3 weeks in custody until the cash bond was posted. I do think that these cases, a lot of times people find themselves in a similar situation, but without a court order, you find out that dads many times don't have rights to their children. Children can disappear for months. I've seen that before. This was a matter of hours. I think the distance was concerning, and just kind of the way that the incident happened was concerning. But the amount of time is minimal, and this still had some serious consequences for Ms. Newman. There's also the reliance on the restraining order here. Now that there is another court order, potentially could be more serious in the future. So I think everybody's protected here. Thank you.
Thank you. Ms. Newman, do you care to make any statement with regards to this matter?
I don't know, I just want to say sorry, and I could have did it a different way.
All right, thank you. I believe that the recommendation to the court is appropriate. I'm going to sentence you to 19 days, time served in jail. The $1,000 fine for the 25 CF 57, and I'm going to assess $150.10 for the TR matter with 0 points off of your license. I think this is a wake-up call, and you understand that grandparents and fathers who haven't went through the right channels don't have the right to just take the children when they want to take the children, especially against a guardian's wishes, when they are the ones who have the ability to make those decisions. You would have to work that out with the guardian. So I do believe that this is appropriate. You have $500 cash, which would be applied to the matter. I am going to order that the remaining be paid in the amount of $100 per month or paid off in full within 45 days. If you fail to make your payments of $100 a month, not only will the court enter a civil judgment, you could sit an additional 6 months in jail for an additional contempt for failing to pay the court-ordered fines and fees. Okay?
We're here on a petition regarding Keaton and Ariana, Jackson, who are both minors. This is a request for removal of the two children. Ms. Jackson, I want to make sure that you understand what's happening today. There'll be a little bit of testimony taken in a moment, but I want to make sure that you understand what is being alleged here. Have you received a copy of the petition from the Department of Health and Human Services?
Yes, sir.
Have you had a chance to read through that?
I just skimmed through it.
All right. Do you want me to read it to you, or do you know enough about it to be satisfied right now?
I am good for right now. Thank you.
All right. If you need any assistance in the future, let me know about that.
Okay.
We are going to appoint counsel for the kids. Do you want me to appoint an attorney for you as well?
Could you please?
All right, we will do that. Obviously, it will require us to continue this hearing at a future time to make sure that they can be here. But we just got a few more things to do today while that is pending. But I certainly will appoint counsel. So we'll do that for the kids. We'll do that for you.
Thank you.
And then I want to make sure that you also understand what your rights are. Not only do you have the right to have an attorney, but you have the right to have a trial by a judge or by a jury if you want to do that in the future. And you also have the right to make a plea of admission or denial. I think until you get an attorney, we'll simply enter a plea of denial at the moment because that preserves your rights to go forward. Mr. Sommerfeld, do you wish to proceed as to the court determining whether or not to remove the children from the home?
Yes, Judge.
How would you like to do that? Do you have testimony for me today?
Yes, I have Ann Sullivan from the department. She did file, she authored the petition.
All right. Ms. Sullivan, would you raise your right hand so I can take testimony from you? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Sommerfeld, do you have questions for her?
Yes. Ms. Sullivan, how are you employed?
I am a CPS worker with the Otsego County Department of Health and Human Services.
Okay. And did you just file a petition today on two children, Keaton and Ariana Jackson?
I did.
And are they both under the age of 18 years old?
Yes, they are.
And where are they domiciled?
Otsego County.
Okay. And who is their mother?
Stephanie Jackson.
Were you able to determine if there was any Native American heritage here?
There is not.
Okay, and how did you get that information?
From the mother.
Okay. So tell us, why are we filing this petition today? Just in kind of summary, general terms.
Okay. So I was assigned a complaint last week due to Ariana having some attempts. She had 3 attempts within a 2-day period. There were several concerns based upon past CPS history that also continue to be an issue currently. So essentially the petition was filed due to concerns of Stephanie's physical health as well as some concerns for maybe mismanagement of medication, and then also for Ariana's mental health concerns.
Okay. Were there some significant issues with mom and her ability to parent or inability?
Yes, on Thursday last week, I'm sorry, on Friday last week, Stephanie's children found her in the home and had to call ambulance for her to be taken to Otsego Memorial Hospital. She was even hours after she arrived at the hospital, she was still incoherent, not able to really speak a whole lot. That would hinder her ability to care for the children. This was the fourth separate occasion in which the children have found her.
Okay. When in your petition under relevant CPS history, there were past substantiated cases of mom being under the influence with children in the car during the last 10 years.
Yes, there were two occasions where she received OWIs or OWIDs.
Okay. And is custody of the children with the parent, does that present a substantial risk of harm to the children's life, physical health, or mental well-being?
It does.
And can you tell us why?
Due to Ariana's attempts and failure to seek appropriate care and follow the recommendations of mental health professionals, and also due to Stephanie's incoherent portions at times.
Okay, was there any provision or service or other arrangement except removal of both children that was reasonably able to safeguard the children from the risk that you just described?
Correct. Stephanie's been offered several services throughout the previous ongoing CPS cases.
Okay. Is it contrary to the welfare for the children to remain in the home of their mother at this time?
Yes, it is contrary to the welfare of the children to remain in the care of Stephanie, as the children are at imminent risk of harm due to Stephanie's inability to seek appropriate treatment for Ariana's mental health and well-being, Stephanie's inability to maintain her prescription medication regimen and to take medications as prescribed, which has led to multiple lengthy hospitalizations and hindered her ability to provide adequate care and supervision of the children.
Okay. Did the department make reasonable efforts to prevent this removal?
Yes, reasonable efforts include ongoing CPS cases, housing assistance, Medicaid, food assistance, substance abuse treatment through NMSAS, Families First, drug screens. She was provided a lockbox, Women's Resource Center, medical care throughout Otsego Memorial Hospital, and Munson Healthcare in Grayling, safety plans and counseling through the Department of Northwestern Michigan for Ariana, and a CMH evaluation for Ariana.
Okay. And so with the removal of the children, custody away from their mom at this time, is that adequate to safeguard both of the children, their health and welfare?
Yes, it is.
Can you tell us why?
Because Stephanie is not able to adequately supervise the children when she's not taking her medications as she's prescribed. She was recently hospitalized for not taking her medication as prescribed, and she was not able to provide proper care for the children. Ariana has attempted on 3 separate occasions within a 2-day period, and adequate mental health treatment or recommendations were not followed at that time.
Okay, and you're asking the court to authorize this emergency removal order based upon your testimony?
Correct.
All right, Judge, I have nothing further.
All right, Ms. Jackson, do you have any questions for this witness?
No, sir.
All right, Ms. Sullivan, let me just kind of make sure I've got everything. The removal date for the kids would be today if I authorize that petition. Is that correct?
Correct. The placement is going to be with a relative in Marquette, so we would do parenting time today prior to taking the children to Marquette.
All right, and it's my understanding from the petition that you filed that the father is Michael Jackson, and he has been deceased since December of 2021. Is that correct?
Correct.
And Ms. Jackson, the mother received notice today of today's hearing from you. Is that also correct?
That is correct.
Let me just make sure I don't have any other questions. All right, the children, you anticipate the children will be placed together at the family placement, is that correct?
They will be.
And do you need any medical releases from mom?
I don't believe so.
All right. Are you aware of any other continuing jurisdiction from another court?
There is none.
All right, I believe that's all the questions that I have. Thank you very much. All right. All right, I will find that a petition has been submitted alleging that the children come within the provisions of the statute MCL 712 8.2b. The children are not subject to the continuing jurisdiction of another court. Notice was given as required by law. There is probable cause to believe that the father is deceased. There is good cause to adjourn the preliminary hearing to appoint counsel. To mother and children. Ms. Sullivan, you are requesting immediate removal to protect the safety of the children. Is that correct?
Correct.
All right. I do find that under the testimony given that there is, in fact, custody of the children where the parent would present a substantial risk of harm to the children's physical health and mental well-being due to the failure to seek appropriate care for Ariana's mental health, and because of the incoherency over a substantial period of time of the mother requiring her hospitalization as well, or medical care being provided. I do find that there is no provision of service except removal, which is reasonably necessary to or available to safeguard the children's from that substantial risk, and that to continuing the children in the residence is contrary to the children's welfare, as mom is not ensuring Ariana's mental health treatment, and her incoherency is a lack of proper supervision, especially given the history of the 3 suicide attempts in a matter of 2 days. I also find that reasonable efforts have been made to prevent or eliminate the need for removal, including CPS cases, ongoing CPS cases, housing assistance, food assistance, substance abuse treatment, Families First, drug screens, Women's Resource Center, and all those other treatments indicated on the record. And I do find the conditions of the child away from the parent are adequate to safeguard the child's health, the children's health and welfare, because mom is not adequately able to supervise the children when she's not taking her medication as prescribed. She's been hospitalized for not taking her medication as prescribed, and she was not able to care for the children appropriately given Ariana's recent suicide attempts over a 2-day period 3 times, and her recommendations were not followed. So for all of those reasons, we will continue the hearing. We'll appoint counsel. We'll authorize the department to remove the children today and provide them, mom, with a little bit of parenting time prior to their removal to Marquette and placement under the auspices of the department. And then we will reschedule this hearing as quickly thereafter and proceed there. Mr. Sommerfeld, is there anything else that the court needs to do today?
No, Judge, it's all covered.
All right. Ms. Jackson, you are going to receive notice from the court as to when the next court date is, and you'll be able to appear like you are now under Zoom. The department indicates to me that they're going to let you see your kids today before they are removed, and they may be able to assist you with some sort of notice as to when you may be able to have contact with the kids. That's up to the department, but you can certainly ask for that if you wish. And then we'll address it again once we have the next court date. Do you have any questions for me, Ms. Jackson?
No, sir.
All right. Ms. Sullivan, I assume that you have mom's address and know where to get a hold of her and all that kind of stuff as well?
I do. Do you need me to email it to the court?
If you would, please, so that we can make
Okay.
sure that we send out notices appropriately to her. All right,
Okay.
that's
And I
all
will
for
provide
today.
her with a copy of the order.
I have one more. It's a joint citation with Trooper Kennedy.
All right, is that the Stowe matter, Garcia Stowe?
Yes.
All right, I actually have three of them involving him, but is John Garcia Stowe present?
Yes, I'm here.
All right. We have three matters that we're dealing with. I see two troopers here. Mr. Garcia Stowe, could you start your video, please?
My camera's on. I think it's you guys that have my camera off.
Mr. Horgan, is that on our side?
I just turned it off and back on again.
It says that his video's on, so I'm not sure what's going on with his camera.
And my, my camera's on as well.
We'll go ahead. We'll go ahead. Don't worry about it. I'd ask all three of you then to raise your right hands, please. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. All right. Okay, so I'm going to go ahead and hear from the troopers in whatever order they want to. I have a registration plate violation charge, a defective equipment charge, and the third one is another defective equipment charge. So please be sure to tell me which one you're talking about as you start. Trooper Kennedy or Trooper Wenner, who wants to go first?
I'll go first, Your Honor.
Okay,
Trooper Kennedy.
go ahead.
So on April 5th, approximately 1:20 in the morning, Trooper Wayner and I were on patrol on M32, just west of town. While traveling, I observed a vehicle that had a out headlight. I believe it was the driver's side headlight that was out. I flipped on the vehicle, conducted a traffic stop, and contacted Mr. Stowe. Prior to contacting Mr. Stowe, I observed that he had a improper display of the tab on the license plate. He had a 2024 green tab, not the new 2025 or 2026 orange tab. And then I contacted Mr. Stowe. While talking with him, I observed that he also had a cracked windshield. And Mr. Stowe was very aggressive throughout the traffic stop and was very defensive. And I would just like to make that a note of the court.
All right, thank you. Trooper Wenner, did you wish to add anything?
I do, Your Honor. Just to explain, when contacting Mr. Stowe, he refused to identify himself at first. I was an FTO. Trooper Kennedy was on probation. While I conducted
Trooper, what could you tell me what FTO means?
Oh, field training officer.
Okay, all right, thank you. Go ahead.
I was at the passenger side. I was there for approximately like a minute and a half, and I observed that.
Did it freeze up, Mr.?
Yes, he's logging back in right now.
All right, we'll see if that works. Okay.
I'm sorry, Your Honor. Can you hear me?
Yeah, I can hear you. You're just starting to say you're talking to. I really didn't hear anything what you said, other than you're the training officer.
Yes, sorry about that. I'm at training, so I'm doing this in my car in the parking lot. My phone went into emergency temperature mode, so just had to switch devices. So at that time, I observed that my probation trooper was having difficulty with the driver. I then went over to the driver's side to hear what was going on. The driver, Mr. Stowe, was refusing to identify himself to us. I explained to him that if he failed to identify himself, he'd be under arrest for obstruction of justice. We went back and forth just very slightly, and he ultimately decided to show his identification to the trooper, or to Trooper Kennedy and myself. I advised him they had a cracked windshield. Himself and the passenger advised that they were not going to fix the windshield, that they did not have to. We explained to him that the defective equipment had to be fixed. Again, they weren't going to fix it, and the registered plate was expired. I advised my probationary trooper to take all that into account, that the typically defective equipment would be waived, but in this process that the individual himself already stated that they weren't going to fix that issue. So that's the reason why the defective equipment was not waivable, because the defendant didn't want to fix it anyways. Ultimately, I wrote him for the citations for the defective equipment for the windshield and headlight, and then displaying a tab that was improper for expiration.
All right, thank you. Mr. Garcia Stowe, what did you want to say?
Well, I wanted to let you know that I do have the passenger here, so she can speak too, since she's being brought into court. It's her vehicle, but I didn't say I wasn't willing to fix my headlight. I told them that I already had a fix-it ticket from Officer, let's see, I have the ticket here, Beauvais, and it's signed for 4/7/25. But during the state of emergency, my headlight was out. I let them know that I was waiting for a part, but nowhere was open during this time to get the part. It's not my vehicle, and we showed them that we had the tag. It just wasn't on because of the ice storm we were in the middle of, and that the car was too covered in ice, and it's wet, so I didn't want the sticker to fall off. And then I did give them registration. I actually held my identification, proof of insurance, and registration against the window for them. So they wrote me the tickets because I didn't want to give them my property. And then also it was because of the fact that there was 4 to 5 other squad cars at the scene for an out headlight. So it was, you know, we were in the middle of rendering aid to people that were elderly and unable to get aid from the police officers. So we were just trying to be good citizens and help people that couldn't get help themselves. Yes.
All right, you said you had somebody there with you. Did you want her to testify as well?
Yes, Your Honor. She's the
Hi,
passenger,
ma'am.
the owner.
Hi,
What is your name?
Leah Deardor.
All right, ma'am, if you'd raise your right hand, please. And do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, go ahead. What did you want to say?
Well, it is my vehicle. The vehicle is registered to me. We did have a out headlight, and a cracked windshield. The windshield was from a tree that during the ice storm. My grandmother is 94 and she's on hospice, and she wasn't able to even get hospice care, and my uncle's disabled. So we were out rendering aid to my disabled family members, or else I wouldn't have drove. If I didn't need to, we wouldn't have drove the vehicle. We would have waited until we had the new headlight that we had already ordered. And I could get receipts to show you that that was already pre-ordered prior to this ticket, along with that prior out headlight ticket that we had received before. It was a waivable ticket. So we had already had a waivable out headlight ticket that we were still in the midst of being able to fix. It was less than 10 days old. So my as far as that goes, yes, it was registered as well. The vehicle was registered. We had the ticket, the sticker on our dashboard. Because it's, as you know, it was a really rough winter. So, and other than that, I mean, prior to that, I had called, we got pulled over twice that night on the way to my grandmother's. We had gotten pulled over for the out headlight, and I explained to the officer I was on my way to my grandmother's, showed him our waivable ticket for the headlight ticket, and he let us go. I did call and I voiced concerns because during the state of emergency, my grandmother and my uncle both had called to try to get help, to render help. And 911 said they could not help unless it was a life or death emergency. So after the first initial stop that we got pulled over and got to go that evening, I had called up to the station to try and talk to the supervisors to say, hey, I wanted to talk and find out if there was a way we could try to help aid, because if we were getting pulled over out headlights and people were still not being followed up for, you know, their
they weren't being followed. There was no follow-up on these people who were calling and needing help. So I was calling to voice my concern. I wasn't calling to complain about any officer. It was to voice my concern about, hey, what can we do to help? I don't know, the lady had said that the main supervisor wasn't in, I'd have to call the next day. And then we got pulled over again after leaving my grandmother's house. So I don't know if that was in retaliation, I'm not sure, but we were only trying to help be out there. And yes, we did have, we had an out headlight. Yes, we did have a cracked windshield from a tree that fell. But yes, my vehicle was registered. It just didn't have the sticker on the plate, but it wasn't a vehicle with us.
Did you or Mr. Garcia Stowe tell the officer, and listen to my question carefully, please. I'm not interested in the other parts, but did you tell them you had the sticker right inside your car?
Yes.
We provided it to them.
Hold it one at a time, please. One at a time. I'm asking Ms. Deerdorf. Ms. Deerdorf, did either of you tell the officer that? Officer that?
Yes, we did. We showed it to him.
Did you show it? All right. Now let me ask the troopers, did they have a sticker there? I don't care which one of you answers. Did they have a sticker there with the new tab? Trooper Kennedy, do you want to take a shot at it?
I don't recall seeing the tab, the actual sticker. I remember seeing the registration.
All right. Did they tell you they had it?
They told me, they advised me that the vehicle was registered. They didn't tell me that they had the sticker itself, but they did tell me that the vehicle was registered, and we confirmed that with our computer.
All right. Okay. Or else it would have been, okay. All right. Mr. Garcia, you heard what Trooper Winter said. I think that was him and not Trooper Kennedy, about your reluctance to identify yourself, and that he had to advise you that you were facing a serious charge if you didn't do that. Did that occur?
I was asking before I provided my ID, I wanted to know why I was being pulled over. They didn't advise me, and then until the second time they said, well, we pulled you over for the headlight, now it's for the cracked windshield. And then I showed him my identification under threat to be arrested.
Well, I don't know if that's under threat of being arrested. That's simply advising you as to what the law says. But Trooper Winter, is that what happened from your perspective?
I think he'd be probably mishearing it, but it was Trooper Kennedy explains the reason for the stop at initial contact to avoid all this. I think he just simply did not want to abide by the laws of the roadway, as he showed a pamphlet as a sovereign citizen to my partner. They didn't have to provide since they were traveling and they weren't actually driving. So I think he's remembering it probably just slightly differently, but the video does state that the reason was advised to him, why the stop occurred. He did not like that reason. He did not want to show his identification. And me as a senior officer, as a FTO, I've been through this kind of ordeal multiple times. I did not threaten him. I simply advised him of the law that if he failed to identify himself, that he would be placed under arrest. That is why multiple other cop cars showed up, is that we do know that when we have to extricate someone from a vehicle because they're reluctant to show identification when they're under arrest, that's why we need multiple bodies to ensure everyone's safety. So I think he's just remembering might be a little bit differently, but the reason for the stop was told, and he was advised that if he didn't identify himself, and that's when he finally did.
All right. Well, here's what I'm going to do with this. I guess I had somewhat misread my files. I have 3 different files, but they're all the same day. They're the 3 tickets that the officers were talking about and that Mr. Garcia Stowe was talking about. But I'm going to reference each file separately. The defective equipment one, and it's hard to tell which one it is, whether it's the windshield or the headlight, but I'm going to find responsibility for that. And that one, the fine is $115. That's file 25X4508107, although these all appear to have the same numbers. On the registration plate violation, I'm going to, well, let me ask the troopers if you recall, what was the month that the registration or that the sticker was supposed to be on? Was it supposed to be on in March? Was it back in January? Do you recall?
The registration should go off of Mr. Stowe's birthday, which I believe is in February. If you don't mind if I reference the ticket real quick.
All right, well, you don't need to. I mean, is that accurate, Mr. Stowe? Well, it's Ms. Deerdorf, is this your vehicle?
Yes, it's my vehicle. And it was, I got the ticket or the sticker, I want to say maybe it was in end of February. Because the vehicle was not.
Why didn't you put it on between February and April 5th?
Because of all the snow that we were getting. Because it was confused.
My birthday's in January, and every year I put it on. It's colder than heck, but you just got to do it. I mean, that's
Well, I
the way to
didn't
do
know. I
it.
thought, in my defense, I will say, and I will take accountability for that. That's my.
Danielle Sierra Coleman, 21W829333. Your name?
Danielle Coleman.
What do you think I'm thinking?
It's been a long time.
4 years. Why are you doing this?
I just let time go by. I got my ticket on my way to work, and I no longer work there, so it kind of slipped my mind.
Slipped your mind. I love when people say that to me. I'd like a lot of things to slip my mind too, you know what I mean? I'd like my mortgage payment to slip my mind. I'd like to forget to pay my insurance payment, my DTE bill, all the other fun things that go around with earning the right to breathe in this society. You have this to pay.
Now I need time to pay it.
How could you've had 4 years? Where do you work?
Well, currently I'm unemployed.
Why?
I just left my job.
Where?
I worked at Toledo Jeep. I just graduated from nursing school 2 months ago.
Hang on, Toledo Jeep plant you were working at?
Yes.
How much were you making?
At that time, maybe $27 an hour.
You worked 40 hours.
Yes.
So 40 times 20 is 800. 40 times 7 is 280. You're making 1,080, but you were making more than that because you were probably working some overtime, right?
No, I was actually in school at the same time.
So you're only working 40 hours.
I was working around 40 hours, yes, sometimes less because I was a full-time student as well.
So I'm curious, you didn't show up in 22 for your show cause, March of 22. Why weren't you here then? I mean, these things I just don't get, okay? I don't understand the lack of respect for the system, but that's just me. You know, I was raised by a judge and a Marine Corps major, and well, I'd have never done this. And I'm not saying everybody should be like me, but boy, you just don't show up for 4 years. Now you come in here 4 years later after you blew us off 3 years ago on a show cause, and you want time to pay? I mean, seriously, this is frustrating part about this job because I just don't understand. Are you a nurse now?
I'm prepping for my state boards.
How much do you have?
I have 100 today.
When can you pay the rest?
I can pay it before the end of this month, so
Are you sure?
the first week of August.
Pay 100 today. Pay the balance by August the 15th.
Okay.
If you don't have the money on August the 15th, you call the court on or before August 15th. You and I will go on Zoom. I'm not even gonna make you drive here. You still live in Southfield?
No, I'm staying Wayne.
Do we have her new address, Lisa?
No, we have a Southfield address.
What's your new address?
Westwood Drive.
I'm sorry,
Westwick Drive.
Westwood?
Westwick.
Is that the same word?
Yes.
WESTWICK?
Yes.
Westwick Drive, and that's in Warren?
Wayne, Michigan.
Wayne, I'm sorry. And the zip there again?
48184.
All right. If you don't have the money, you call the court, we'll go on Zoom, or you can come in here on or before the due date and ask for an extension. Stop blowing courts off like this. This is not good. You seem like a very intelligent, nice lady, but you can't do this, okay? All right, best of luck. Albert Leon Trace Brown. 24G82738. 24W836241. Name? On January 6th, I arraigned you for failure to pay 133, pled guilty. I told you to pay by January 27th. This is July the 8th. On the other case, you tendered a plea of guilty to failure to pay 193. I ordered you to pay by February 17th. This is July the 8th. I also told you to come and talk to me if you didn't have the money. Did I do that or not?
I believe you did.
I'm sure I
I'm pretty
did.
sure it slipped in my mind.
Slipped your mind?
Yes, sir. No factuality. I ain't no lie to you.
I'm sorry?
I said, I'm not even gonna lie to you.
Well,
Yes,
that's,
slipped my mind.
it slipped your mind.
Yes, sir.
I wish it slipped my mind to pay my tax bills that I just got. You know that? I'm serious. Now listen to me.
Yes, sir.
It's time to grow up. How old are you?
I'm 23.
Well, what are you doing?
Honestly, I'm paying my own bills.
Where do you work?
I just started actually like
When?
2 weeks ago.
What were you doing before that?
I didn't have a job.
Why not?
My car broke down. I literally just got a ride up here today. I promise you. Like, I have a son and everything. I own my own house.
When did you last work before starting the painting work 2 weeks ago?
A good 6 months to a year.
So you couldn't get your car fixed because you didn't have the money.
Yeah.
Does it make, hang on,
Yes, sir.
does it make any sense to you that you wouldn't find a job and figure out a way to get there?
I've kind of been trying.
Kind of been trying.
I understand. I know it seems like I'm not as much as I could be, but I honestly been trying as much as I can.
Where'd you apply?
A job called Single Source. I actually paid.
I know, but where'd you apply in the last 6 months to a year? Sounds like it's been longer.
McDonald's, Wendy's, every fast food.
Where?
E-quarters.
Where, hold on. Where in E-quarters or on E-quarters?
On West Jefferson. I live right off West Jefferson.
You applied at McDonald's?
Yes, sir.
They wouldn't hire you?
No, sir.
Where else did you apply?
I've also applied at Wendy's.
Where?
Burger King, Subway.
Wait.
Okay.
Come on. Slow down.
Wendy's.
Wait, Wendy's where?
Wendy's in Gibraltar.
You were gonna somehow get to Gibraltar without a car? Now listen to me.
That was.
Hang on. You didn't have a car, so you couldn't get a ride and you couldn't get to work. And you live where?
I live in Eagle.
All right. Does it make any sense that you were applying to Gibraltar? Whoever's got the phone, it's got to leave the building right now, please. Got to take the phone out of the building.
Whose phone went off?
Sir,
Gotta go out.
in the white t-shirt. Whose phone went out?
Yeah, let's
It might have been mine, sorry.
Got to take it out of the
Let's
building.
make sure your phones are off. Do something.
Does that make any sense?
No, sir.
Do you know how much you've just convinced me that you haven't been trying?
I understand.
I know. Now look, if you want to go your whole life in poverty, that's your choice. But don't come up here and start telling me stories. All I asked you to do, if you didn't have the money, call the court, we'd go on Zoom. You couldn't even be bothered to do that, even though you're sitting around the house for 6 months to a year. Now look, whether you end up in poverty or not, when you're 25, 35, 55, it's no skin off of my neck. But figure out a way to make a living. Really. I don't understand why people do this to themselves. You couldn't even be bothered to call the court and talk to me and say, Judge, I don't have the money. But you're just telling me stories now. I don't want to hear stories. Listen to me. I hear stories every single day. I'm surprised I don't lose my cool a lot more. I get tired of having people stand there and lie to me. I'm not sure you don't deserve to go to jail today. How much money do you have with you? How could you have money? You don't work.
I just paid all my money towards my bills.
Well, you've only been working for 2 weeks of the last year. How could you possibly have money unless you're a trust fund baby and they're giving you a couple $100,000 a year? This ticket has been outstanding now for 10 months. I'll give you one more chance, but if you do this again, I'm sending you to jail. Do we understand one another?
Yes, sir.
Are you sure we understand one another? Are you sure you understand that if you don't have money, that you at least have the courtesy of either coming in here and talking to me or calling on up and saying, I need to talk to the judge about an extension?
Yes, sir. But I give you my word.
My word. You know how many times I've heard people give me their word that they don't follow through with?
2 weeks, sorry.
And I've never had anybody come in here and tell me in 30 years and 7 months that they're coming back. You tell me when you can pay the speeding ticket. Well, you owe $38 on the parking. When can you pay? I'm gonna let
Next week.
Are you sure?
$38 next week.
Slow down.
Yes, sir.
Slow down. Are you sure?
I'm 100%.
I can give you more time if you need more time.
I'm about, well, just in case, how about the week after? Just in case. But I'm pretty sure I can have both tickets paid by next week.
Okay. I'm gonna do better than that. I'm gonna pay this parking in full by July 25th. That's 2.5 weeks. And I'm gonna give you on the other case that you owe 193 on. did you say that you own a house, right? Do you have any kids?
Yes,
I thought you said
my son back
that.
there.
Where?
He's like, those are big ones. That's my son right there.
Good.
That's what I'm saying.
You don't want him to be in
Where's
poverty.
that?
You don't want him to be in poverty, right?
No, sir.
Okay, I'm gonna give you until August the 8th to pay the other one. Given the fact that you told me you could pay both by next week, I've been more than fair now. If you don't have the money, come talk to me. Call up. I'll go on Zoom. I'll give you an extension. I hate this when people ignore courts and then come in here with stories. Good luck. Thank you. Stop it. You owe it to that child to provide a roof over his head.
Okay, so the first case with Judge Mertz, it seemed to me that the wife wanted all the money from the divorce immediately. And it sounds like she either can't do anything without her husband's money or without their joint money that they had. But how is she going to support herself on half of his pension? She can't. She's going to need a job. If she doesn't already have one, she needs to get one. Anyway, that's all I have to say about that. And then, let's see, the CPS removal with Judge Hesselink, I just thought that was incredibly sad. It was just sad. I mean, I felt for the woman because, she lost her husband a couple of years ago, and she probably went off the deep end, and she hasn't been able to get back to where she can stand properly. And she's got some issues she's got to deal with. And it's best that the little ones not be with her when she deals with all this stuff. Now she's got time, and she can go to therapy and, all these other things. She can't fall back on I didn't have time because of, taking care of my little ones. So, and then, let's see, what was the other one? Oh, Judge McNally, I just, me, I love him, so I had to put him in. So thank you guys so much for watching. I wanted to say I am sorry about missing last night, but I have an infection in my thumb, and I've had it for 2 months, and it gets better, and then it gets worse, and it gets better, and it gets worse. And I've been on and off antibiotics, and they switched me to a new one, and it's just making me feel like crap. So that's why I missed last night. I just didn't feel good. Thank you guys so much for watching, though, and I'll see you next time.